In California, one family recently lost $46,000, not to a lawsuit, not to the IRS, to their own local courthouse. Statutory fees on a $1 million estate, $23,000 to the attorney, $23,000 to the executor. Automatic, written into state law. And the only reason it happened is that nobody signed one specific piece of paper years earlier. Here's the state of estate planning in America right now. Only 31% of adults have a will. Just 11% have a trust. That means 55% of the country, more than half, has neither document. Zero instructions, zero protection. Just hoping a courthouse sorts it out fairly when the time comes. And here's what makes this genuinely confusing. Half of YouTube tells you, just get a trust, it's always worth it. The other half says, a will is all anyone actually needs. Trusts are a scam for the middle class. Both of those are wrong for a huge chunk of the people watching this. So in the next 20 minutes, what a will actually does, and the huge misconception about what it does not do. What a living trust actually is, and the single mistake that quietly cancels it out even after someone pays for it. A 2026 number that kills the trust saves you from estate tax myth for the overwhelming majority of American families. 4 real households, 4 different right answers. And a 60-second framework to figure out exactly where your family lands. Quick disclaimer. Estate law varies enormously by state, and this is education, not personal legal advice. For your actual documents, use a licensed estate attorney in your state. Let's get into it. What each document actually does. Let's start with definitions, because most of the confusion out there starts right here. A will is a set of written instructions that only takes effect the moment you die. It names an executor to carry out your wishes. It says who gets what, and, this one's important, we'll come back to it. It's the only estate document that can name a guardian for your minor children. A trust cannot do that. Only a will can. Here's the misconception that trips up almost everyone. A will does not avoid probate. It never did. A will is basically a letter to the probate court telling the judge exactly how you want things handled. The court still has to open a case, validate the document, and supervise the process. And if you die without a will, what lawyers call dying intestate, you still get probate. You just lose the ability to choose your executor or your distribution plan. The state's default formula and a court-appointed administrator take over instead. A living trust works completely differently. You create it while you're alive, that's the living part, and then you fund it, meaning you retitle your assets so the trust legally owns them instead of you personally. You're typically the trustee and the beneficiary while you're alive, so nothing about your day-to-day life changes. You name a successor trustee who steps in when you die or if you become incapacitated. Because the trust, not you, technically owns the assets, there's no probate needed when you pass. The trust doesn't die, it just changes hands. Quick naming confusion alert, because this one causes real problems. A living trust and a living will are 2 completely different documents. A living trust holds property. A living will is a healthcare directive. It states your end-of-life medical wishes, like whether you want life support. Totally different jobs. And regardless of which path you take on the will versus trust question, you also need 2 incapacity documents that have nothing to do with dying at all. A financial power of attorney, so someone can manage your money if you're unable to, and a healthcare directive, the living will, plus a HIPAA release so doctors can even talk to your family. Skip those, and a temporary illness or accident can freeze your entire financial life. Probate. Actually explained. So what is this probate thing everyone's trying to avoid? Let's demystify it, because most people fear the word without knowing what it means. Probate is the court-supervised process of settling an estate. The judge validates the will, or applies state law if there isn't one. The executor inventories everything you owned, appraises it, publishes a notice so creditors can make claims, pays your debts and final taxes, and only then distributes what's left. Every step goes through the court. Every filing becomes part of the public record, meaning, in most states, anyone can walk into that courthouse and see exactly what you owned and who inherited it. Generally 3 to 8% of the gross estate. Not the leftover equity, the gross value, before debts are even subtracted. That's attorney fees, executor compensation, court filing fees, appraisals, a surety bond, and the newspaper notice to creditors. Remember that $46,000 California example from the intro? That's what 3 to 8% looks like on paper, turned into a real invoice. Typically 9 to 18 months for an average estate. Contested wills, property in multiple states, or family disputes can stretch that past 2 years. And during all of that, the assets are largely frozen, a house can't be sold, an investment account can't be rebalanced, while the market does whatever it wants underneath it. Now, 2 genuine pieces of good news, because probate isn't a trap for everyone. First, small estate procedures. Every state sets a threshold below which you skip formal probate almost entirely, using a simple affidavit instead. And these thresholds vary wildly. California's is just over $208,000, while Michigan's sits around $51,000. If your estate is genuinely modest, check your own state's number before you assume you need anything elaborate at all. Second, and honestly bigger for most ordinary families, a huge amount of property already skips probate automatically, with or without a will. Jointly owned property with survivorship rights passes directly to the co-owner, and anything with a beneficiary designation, 401ks, IRAs, life insurance, transfer on death bank and brokerage accounts, goes straight to whoever's named on the form, bypassing the court entirely. For a lot of American families, retirement accounts and life insurance are the bulk of their net worth, which means checking and updating those beneficiary forms, completely free, takes 10 minutes, often does more heavy lifting than a $2,000 legal document. But hold that thought, because it comes with a warning label. Beneficiary designations override everything. Your will, your trust, all of it. An ex-spouse from a decade-old 401k form still gets the money, no matter what your will says. We'll come back to this exact trap in the mistakes section because it's one of the most common and most avoidable errors in all of estate planning. 4 families, 4 different answers. Let's make this real. 4 households, 4 verdicts. And notice none of them are always get a trust. Family 1. Priya, single, rents her apartment, 38 years old. Her assets, a 401k, a Roth IRA, a car, some savings. No real estate at all. Her retirement accounts already have current beneficiaries on file. Her whole estate sits comfortably under her state's small estate threshold. Priya's answer? A simple will, mostly so she can name a guardian for her future kids someday and leave instructions in writing, plus a power of attorney and healthcare directive. Total cost? Maybe $300 to $600. A trust would cost her more and protect almost nothing extra, since there's barely any probate-eligible property to protect. Family 2. The Whitfields, a blended family. David remarried after his first wife passed. His new wife, Ellen, isn't the biological mother of his 2 adult kids. He wants Ellen to be able to live in the house for the rest of her life, but when she eventually passes, he wants the house to go to his own kids, not wherever Ellen's estate plan sends it. A will can't really do this safely. Leave the house outright to Ellen, and legally it's hers to redirect however she wants, even away from David's kids entirely. A trust can build that exact staged instruction directly into the document, a life interest for Ellen, then a guaranteed handoff to David's children, enforced by the successor trustee, not by anyone's goodwill. This is precisely the situation a trust was built for. Family 3. The Ortegas own a home in Colorado and a lake cabin in Wisconsin. No trust means 2 separate probate cases in 2 separate states when they pass, called ancillary probate, doubling the attorneys, the court filings, and the timeline. A living trust that holds title to both properties sidesteps that completely. One trust, one administration, regardless of how many states the real estate touches. Family 4. Robert, 69, recently widowed, mild early memory concerns. His biggest fear isn't dying, it's a stroke or advancing dementia leaving him unable to manage his own finances while he's still alive. A trust's successor trustee provision means someone he's chosen can step in immediately if that happens, no court involved. Without it, his family would likely need a court-ordered conservatorship, called guardianship of the estate in some states, which is slow, public, and can cost thousands before anyone can even pay Robert's electric bill. See the pattern? 2 families skip the trust entirely and come out ahead. 2 families would be taking on real, avoidable risk without one. The myth, the 2026 numbers, and the mistake that breaks trust. Now let's kill the biggest myth in this entire topic. Get a trust, it'll save you on estate taxes. For federal purposes, that's simply not true for the vast majority of people watching. Under the tax law signed in 2025, the federal estate and gift tax exemption for 2026 is $15 million per person, $30 million for a married couple, made permanent, and it climbs with inflation from here. That means the overwhelming majority of American estates will never owe $1 of federal estate tax, trust or no trust. And here's the part that surprises people. A revocable living trust provides zero income tax or estate tax benefit while you're alive. The assets are still legally yours for tax purposes. You report the income, you own the value, exactly as before. If a salesperson's main pitch for a trust is tax savings, and you're not sitting on 8 or 9 figures, that pitch doesn't hold up. This is squarely a probate and control tool, not a tax tool for nearly everyone. One asterisk, and it matters. State estate or inheritance taxes are a separate animal entirely, and several states still tax estates well below that federal number. Untouched by the federal exemption. Worth 5 minutes checking your own state's rules rather than assuming you're automatically in the clear. And while we're on 2026 numbers, a genuinely separate everyday tool, the annual gift tax exclusion. You can give up to $19,000 per person per year to as many people as you like, with zero paperwork and zero impact on that 15 million lifetime number. A married couple can combine that to $38,000 per recipient. Useful for lifetime giving, unrelated to whether you personally need a trust. Now, the mistake that quietly cancels out a trust even after someone pays real money for it. It's called funding failure, and it's shockingly common. Someone hires an attorney, pays $1,500 to $3,000, signs a beautiful binder of documents, and then never actually does the follow-through. The house deed never gets retitled into the trust's name. The brokerage account stays in their personal name. The car title never changes. Legally, none of that property belongs to the trust. It still belongs to the person. So when they die, every one of those unretitled assets goes straight through probate anyway. Exactly what they paid to avoid, and they never found out until it was too late to fix. This is exactly why a trust is a bigger project than a will, not just a bigger fee. It's not one signature, it's a process. Deed transfers, account retitling, updated beneficiary forms on the trust itself. Ideally a check-in every few years as you acquire new property. And here's the twist almost nobody mentions. Even if you do everything right and fund your trust perfectly, you still need a will alongside it, called a pour-over will. It exists for 2 jobs a trust legally cannot do: naming a guardian for minor children and catching any stray asset that never got funded in, sweeping it into the trust after the fact, instead of leaving it stranded in probate. The decision framework. When faced with a tough decision, it's crucial to weigh your options carefully. Consider the potential outcomes and how they align with your long-term goals. Remember, every choice you make is a step towards shaping your future. Trust in your ability to make the right decision, and don't be afraid to seek advice from those you trust. Let's turn all of that into a framework you can actually use. 5 questions. 1. Do you own real estate in more than one state? 2. Is your total estate likely above your state's small estate threshold? 3. Is your family situation more complicated than split it evenly among my kids, a blended family, a beneficiary with a disability, an estranged relative you need to work around? 4. Do you genuinely care about keeping your family's finances out of the public record? 5. Are you worried about a future incapacity and want to avoid a court-supervised conservatorship? 0 or 1 yes? A will, a power of attorney, a healthcare directive, and, critically, a real beneficiary designation cleanup is very likely all your family needs. That's the cheaper path, and it's also the lower maintenance one. There's no funding process to mess up. Several yeses? That $1,500 to $3,000 trust is very likely to pay for itself many times over. Remember the $46,000 California family from the intro? One honest caution before we move on. Because trusts cost more to set up than wills, Some firms make more money selling everyone a trust, whether they need one or not. These get nicknamed trust mills in the industry. That doesn't mean every attorney recommending a trust is doing it wrong for you. It just means it's worth asking directly. Given my actual assets and my state, would a will genuinely be enough? A good estate attorney will give you an honest answer, not just the more expensive one. The mistakes, rapid fire, and your 60-second answer. The classic mistakes. Fast. Signing a trust and never funding it, the single biggest one in this entire video, worth repeating. Skipping the pour-over will even when you have a trust. No guardian nomination, no catch-all for stray assets. Beneficiary forms frozen in time. An ex-spouse or a parent who's already passed, still listed on a decades-old 401k or life insurance policy, silently overriding every other document you own. Go check those today, right now, it's free. DIY documents that don't meet your specific state's execution rules, the number of witnesses, notarization, self-proving affidavits all vary state to state, and getting it wrong can invalidate the whole thing, sending you straight into intestate probate. Never updating the plan after a marriage, a divorce, a new child, a move across state lines, or a major asset change. And one more time, because it genuinely confuses people mid-conversation with their own family. A living will and a living trust are not the same document. Say it out loud once so it sticks. So, the honest 60-second answer to this video's title. There is no universal winner, and anyone telling you otherwise is selling something. For a simple, single-state, modest estate, a will plus your incapacity documents plus clean beneficiary forms is genuinely, completely sufficient. Don't let anyone upsell you past that. Real estate in more than one state, a blended family, a strong desire for privacy, or real concern about a future incapacity, the trust earns its cost, often many times over, but only if it's fully funded and only alongside a will, never instead of one. Your homework tonight? 5 minutes, $0. Pull up the beneficiary designations on your 401k, your IRA, and your life insurance, and confirm the names on them are actually who you want today. That single check is the highest leverage move in this entire video, and most people have never done it once. Everything here is general education on federal rules and typical costs. Estate law is heavily state-specific, so for your actual will or trust, work with a licensed estate planning attorney where you live. If this untangled something that's been confusing you for years, the like button helps more than you'd think. And if you haven't already, check out the Roth versus traditional IRA breakdown and the 2026 standard deduction video, together with this one. That's the core of a solid 2026 financial checkup. See you in the next one.